Instruction issue would require a new trial on.
Thank you, Counsel. Next case we have is NATIONSTAR Mortgage versus Stephanie ZORIE. Got NATIONSTAR, okay.
Oh, that's because of the change of hand.
The next one, yeah. I'm on this one, so.
Okay. All right, and counsel for the appellant, how much time would you like for rebuttal?
I'd like to reserve 5 minutes, please.
Okay, you may begin.
May it please the court, Michael Larson on behalf of NATIONSTAR Mortgage. Ms. ZORIE has not made a mortgage payment in 6 years. NATIONSTAR is the holder of the note, endorsed in blank, and is entitled to enforce its terms. Judgment on the pleadings in favor of Ms. ZORIE should be reversed based on multiple grounds. First, Ms. ZORIE has failed to satisfy the judgment on the pleadings standard. Judgment on the pleadings is a very limited procedural device. In order to be granted judgment on the pleadings, Ms. ZORIE must have shown that the complaint fails to state a cause of action and that she is clearly entitled to judgment as a matter of law in her favor. And here, neither of those elements are met.
Let me ask you a question as far as the note goes. There was specifically in the reply or the answer brief, there was an accusation that the complete note was not attached to the complaint when it was filed. You would admit that that was the case, is that correct?
Yes, we do not contest that a complete version of the note was not filed. The original note lacked the prepayment right.
Okay, was that the only clause that was missing from the note that was, or the portion of the note that was filed with the complaint?
Yes, that's my understanding, that the only thing that was missing was the one-page prepayment rider. And we contend that the prepayment rider does not relate to any of the allegations in this case and is therefore
Was
relevant.
there ever a defense raised by the appellee that the appellee attempted to pay the note prior to its maturity?
In this case, Ms. ZORIE filed 2 answers in 2009, and in those answers, she admits that she fails to make payments. And in this case, this is a judgment on the pleading, so the allegations in NATIONSTAR's complaint that Ms. ZORIE failed to make payments must be taken as true in ruling on Ms. ZORIE's motion. So we're confined to the pleadings, and regardless of the allegations in the answer and affirmative defenses, although Ms. ZORIE does admit in her answer that she did miss payments, we're confined to the complaint, and those well-pled allegations must be taken as true. And here we allege that Ms. ZORIE has not made a mortgage payment since 2008. So
You take the position that the trial judge relied upon anything other than the complaint and whatever was filed in support of the complaint at the time of the motion and the granting of the motion?
Yes, Your Honor. We take alternative positions. The first is that NATIONSTAR did not need to attach a copy of the note to its complaint in order to state a cause of action. And that is because the complaint contains a second count. At the time it was filed, it contained a count to reestablish a lost or destroyed promissory note. And because NATIONSTAR alleged that it did not have possession of the note, the case law supports the proposition that a copy of the note did not need to be attached to the complaint in order to state a cause of action. So if a copy of the note did not need to be attached to the complaint to state a cause of action, it was reversible error for the trial court to go and review the original note, which was filed a month after the complaint was filed. The original note, under that theory, is not part of the pleadings, and at the hearing on Ms. ZORIE's motion, the trial court clearly considered the original note. However, alternatively, to the extent a copy of the note did need to be attached to the complaint, NATIONSTAR suggests that the filing of the original note cured any defect in its complaint resulting from failure to attach a copy of the note. And the Hughes case supports that proposition.
There was a cause of action pending on the original note when you had this, what turned out to be the dispositive hearing.
Yes. Okay. Yes, there was a cause of, when we dropped count 2 of the complaint at the time of the hearing. However, count 1 remained, which was a count for mortgage foreclosure. And we had filed,
So in essence, at the hearing, the complaint construed in your favor was, we own and hold the note, she's in default, the original note is filed of record here, and
yes,
met all conditions preceding?
Yes, Your Honor. We allege that Ms. ZORIE executed a note in mortgage, that she was in default, all conditions precedent had been satisfied, and NATIONSTAR is the holder of the note, and we also had filed the original note, which is endorsed in blank. So,
And it had been filed long ago?
yeah, it was filed in 2008, about a month after the complaint was filed. So under either theory, whether the complaint needs to attach a copy of the note or the complaint does not need to attach a copy of the note, NATIONSTAR states a cause of action, which precludes judgment on the pleadings in favor of Ms. ZORIE. And I'd also like to point out the second prong of the test for judgment on the pleadings is not met. Ms. ZORIE must show that she is clearly entitled to judgment as a matter of law in her favor, and given these facts, given her 6 years of default, that NATIONSTAR holds the note, the law does not support judgment on the pleadings in favor of Ms. ZORIE. She is not clearly entitled to judgment as a matter of law. And I'd also like to point out that Ms. ZORIE does not cite any case law that grants judgment on the pleadings to a defendant borrower due to failure to attach a copy of the note to the complaint. And she certainly does not cite any case law that shows failure to attach a single page, a single irrelevant page to the note results in failure to state a cause of action resulting in judgment on the pleadings in her favor. Neither of those types of cases have been cited. And further, I would argue that Ms. ZORIE has waived her argument regarding Rule 1.130A, which is the rule that governs attachments to pleadings. Under Rule 1.130A, it governs attachments to pleadings and says copies of notes, mortgages, contracts should be attached to the pleadings. But here, this is a 2008 case. Ms. ZORIE entered a notice of appearance in 2009. She filed 2 answers in 2009. Neither of those answers raised violation of Rule 1.130A. She also filed 2 motions to dismiss summary judgment in 2009, and neither of those motions raised violation of Rule 1.130A.
Motion to dismiss the complaint.
Well, she has 4 motions here. She filed 2 motions to dismiss our summary judgment motion, and she later filed 2 motions to dismiss. The first 2 motions did not raise violation of 1.130A. She first raised that argument in January of 2011, about 3 years after the case was filed. So we contend that she has waived her argument regarding violation of that rule. And I would also like to address one other waiver argument, which is really, it appears to be the centerpiece of her answer brief, or a major portion of her answer brief. She contends that NATIONSTAR's trial counsel somehow waived its argument that Ms. ZORIE was not entitled to judgment as a matter of law. But if you look on page 15 of the trial transcript, the trial court asked counsel 2 simultaneous questions. The first question is, if you went to trial on this complaint with this note, wouldn't I have to give an involuntary dismissal? Question mark. The next question, the note is not complete, right? Question mark. Counsel responded and said it would not appear as such, Your Honor. So to me, the reasonable inference from that is that counsel simply said the note does not appear to be complete. And here we are not asserting that the note is complete. We recognize that a copy of the prepayment rider was not attached to the note, but this does not result in any sort of waiver on behalf of NATIONSTAR. In addition, I would like to simply point out the inconsistencies taken by the trial court in this case. 2 motions to dismiss were filed. A motion to dismiss is adjudicated using the same standard as a motion for judgment on the pleadings, which essentially is whether the complaint states a cause of action. And here, those 2 motions to dismiss asserted violation of Rule 1.130A. This is in 2012. She started raising the 1.130A argument. And those motions to dismiss were denied. And yet, her motion for judgment on the pleadings, which asserts violation of the same rule, that motion was granted. And we contend it was error for judgment on the pleadings to be granted after 2 motions to dismiss had been denied, arguing the same thing. In addition, Your Honors, it was an abuse of discretion for the trial court to deny NATIONSTAR's motion to amend its complaint. pleading should be amended liberally. The right to pleading amendment should be granted liberally. This is the first time NationStar sought to amend. It only sought to amend one time. Ms. ZORIE would not be prejudiced by an amendment to its complaint. Ms. ZORIE has a copy of the prepayment rider. The prepayment rider was produced to her in discovery in 2011. The prepayment rider also was received by her because it was attached to NationStar's motion for rehearing, so she received a copy of the prepayment rider twice. She has notice of its terms. It would not prejudice Ms. ZORIE to permit NationStar to amend its complaint to add a count for reformation in order to correct any deficiency in the original note. And finally, this case should be decided on the merits, not simply because a copy of one irrelevant page of a document was not attached to the original note. And if the court has no further questions, I will reserve the rest of my time for rebuttal.
Good morning, Your Honors. My name is Stephanie ZORIE. I'm here pro se, but I'm an attorney. I'm colorblind, so this is very confusing to me. I'm just going to ask quickly, the numbers is the time that I have left, is that?
Yes, that's correct.
Thank you very much. There's a number of issues here that were just brought up by counsel. First of all, the complaint on its face did not comply with Rule 1.130. There was no attachment. They had a number of years to amend the complaint, attach the note. They chose not to do that.
Is there a requirement that they file the note simultaneous with the filing of the complaint?
Well, it says Rule 1.30, all bonds, notes, etc., or portions thereof shall be incorporated in or attached to the pleadings. So, in addition...
Case law that supports the position that you must file the note simultaneous to filing the complaint?
I don't have my case law in front of me, but I do believe
Isn't there case law directly opposite that you do not have to file the note simultaneous with filing the complaint?
There is case law that you don't have to file it simultaneously with the complaint as long as you are able to produce a copy of the note. This note was defective on its face.
And the appellant in this case did produce a copy of the note, correct? The complete note eventually.
Eventually, but that was not relevant to the judgment on the pleadings because the judgment on the pleadings only dealt with what was before the court at the time.
Well, and before the court at the time of the judgment on the pleadings was a copy of, albeit an incomplete copy of the note minus the prepayment rider, correct?
Correct, sir.
Okay. And was that the only thing that was absent from the note at the time of the motion for judgment on the pleadings?
From the note itself specifically, but the plaintiffs had withdrawn their count 2 for lost or incomplete note. So before the court was the count 1, the count 2 had been withdrawn, and not only withdrawn, but recorded. And the motions that he discussed earlier that I had filed to dismiss were all heard prior to them intentionally withdrawing count 2, which dealt with the lost note. Had they not done that, I don't think we'd be here today.
How was the failure to have the prepayment rider before the court at the time of the judgment on the pleadings prejudicial to your client or prejudicial to you?
Because it was an incomplete note, and that was what they were relying on. And with an incomplete note, we don't know what the full terms of the note are. I'd like to go back to...
Did you ever take the position in front of the trial court that you had at any time attempted to prepay the note?
Not at that time, no, sir, Your Honor, but
At
that
any
was...
time during the litigation, did you ever take the position that you had attempted to prepay the note?
I had, but no, I did not take that position.
I'm sorry, you had, but you
I
didn't.
had taken those efforts, but that was not in front of the court.
Okay, and that was never any evidence that the trial court considered prior to the motion for judgment on the pleadings,
I
correct?
don't believe so, sir. I think the real problem here is that, well, first of all, they failed to comply with the statutory requirements of 702.015, Section 5, A, B, C, and Section 6. And I believe that is a serious error. They had requested that this matter be set for trial as it stood, and I objected because there had been a number of pending motions. The court went ahead and set the matter for trial on October 10th, 2013. And this was at their request. They were ready to go to trial by withdrawing count 2 for lost note and not having a complete note. And then I would like to refer the court to the transcript that was filed at page 15, lines 10 through 18. And the court said, well, this is a motion for judgment on the pleadings. Mr. Hyde, opposing counsel, said, right, it is. The court, if you went to trial on this complaint with this note, wouldn't I have to give an involuntary dismissal? The note is not complete, right? Mr. Hyde, it would not appear as such, Your Honor. Going back to,
But the original note had been filed, so well years ahead of time.
but not completely. It was not a complete
Okay,
note.
but the prepayment rider, of which apparently was never an issue below, other than you're now saying that at your judgment of the pleading hearing, that, hey, you don't have the prepayment rider.
Correct.
And you admitted in your answers earlier, according to your appellant's counsel, that you had not made payments.
I had missed some payments. I admitted that.
And then they accelerated.
I don't know that. I was not received.
Well, they accelerated in the lawsuit. They said that you missed payment of such and such a date and all further monies are now due and owing, right?
In the initial complaint?
In that, no? Okay.
Quite factually, this was one of those rocket dockets where I was living in the house and an affidavit was filed of due diligence search and I was living it. So this was all, I was hit broadside with this whole case because I thought I was dealing with the mortgage company and making the payments and getting everything organized when this was initially filed.
Well, you're not challenging the fact that the appellant did properly plead all of the elements required in a action in foreclosure, is that correct?
Initially, but when they withdrew count 2 of their own volition shortly before trial and did not have a complete note filed, I think that kicked back to no, they did not have a proper complaint in front of the court, nor did they have a complete note in front of the court. And like, again, it was just shortly before trial. Once they realized their error, then they requested the court to allow them to redo what they had already
So
undone.
the sufficiency of count 1 is dependent on whether or not count 2 is also in the complaint?
If they did not have a complete note, yes, sir, and that goes back again to the statute that has very specific requirements of 702.015. And though this is a later case, the documents behind it, on page 1636, section 8, the legislature finds that this act is remedial in nature and applies to all mortgages encumbering real property and all promissory notes secured by a mortgage, whether executed before, on, or after the effective date of this act. In addition, the legislature finds that Statute 702.015, Florida statutes as created by this act, applies to cases filed on or after July 1st, 2013. However, the amendments to 702.10 Florida statutes and the creation of 702.11 Florida statutes by this act apply to causes of action pending on the effective date of this act, which would include this current case. And by the requirements of foreclosure of mortgage and statutory liens in this statute, they did not comply with that in the initial complaint filed at all. These requirements were not set forth in the initial complaint. So the initial complaint was defective pursuant to that statute. Then we have an incomplete note. And then we have them actually going ahead and intentionally withdrawing their count 2 for loss note. Had they left count 2 in, like I said, I don't think we'd be here. But we are here because of their own actions. And then at the end of all this, they want the court to allow them to redo what they had undone themselves. It goes way back. I'm citing a case. It's called First National Bank of Sullivan at 119 Pacific 820, Washington, 1911. This note, like every other written instrument, must be construed as a whole, so as to give effect to every part of it if possible.
Isn't there Florida case law, though, that says when a complaint is based on a written instrument, the complaint does not state a cause of action until the instrument or an adequate portion thereof is attached to or incorporated in the complaint?
Correct.
Isn't that exactly what we have here?
No, it was never attached to or incorporated in the complaint, Your Honor. And they had a long time to do it.
But they filed the original note a month later.
They filed an original partial note a month
Well,
later.
okay, not having the prepayment rider.
Correct, sir.
Why wouldn't that, but they had all this, the material elements of the document is there in the original note, the amount being borrowed, the repayment schedule, the interest rate, things of that nature?
So things of that nature, but again, we were missing a portion of the note.
I mean, that seems what the whole, that's what you seem to be writing on, no pun intended here, that the prepayment rider wasn't attached, therefore you should be affirmed.
I believe we should be affirmed because of the timeliness of their request to amend their complaint. This is after they have advised the court they are ready to go to trial, a trial date has been set, and then at the end, they want to redo everything. So after
Is that the
5
first
years.
request to amend?
Yes, sir. Yes, sir. And again, after they realized their error, and I don't think the courts are here to tell them of their errors and then try and assist them to recreate their errors. As I saw in the BMW case, again, it's, I think, really similar to this case, where the attorneys made a mistake in the drafting and then wanted the court to help them fix it, and the court did not do that. And I'm asking this court to affirm the lower court's judgment.
Thank you.
Thank you, sir.
You have a little over 10 minutes.
Thank you. I would just like to respond to some of Ms. Zorie's arguments. At the outset, she mentioned that the complaint did not contain any attachments, but the complaint did contain a copy of the mortgage, and it also contained a copy of the note's terms. So even though the copy of the note was not attached, those two documents were attached to the complaint. And it is immaterial whether count 2 of the complaint was dropped in this case. If you get rid of count 2, you're left with count 1, which is a count for mortgage foreclosure. We allege that Ms. Zorie executed a note and she's in default. All conditions precedent were satisfied, and NATIONSTAR is the holder of the note. All the key elements were alleged. We filed the original note endorsed in blank, where NATIONSTAR is the holder of the note and is entitled to enforce the note's terms. And again, Ms. Zorie does not cite any case law that reflects that failure to attach a copy of one irrelevant page to a contract results in failure to state a cause of action, and certainly doesn't cite a case saying that she's entitled to judgment on the pleadings because of that deficiency. We suggest that the prepayment rider is wholly irrelevant. NATIONSTAR's allegations do not involve the prepayment rider. Ms. Zorie's defenses do not involve the prepayment rider. The prepayment rider is immaterial. And further, I'd just like to touch upon section 702.015, which is a statute that Ms. Zorie cited very, very briefly in her answer brief. She just cited the statute in the heading of the answer brief, but did not actually provide argument in furtherance of that statute. So we suggest that to argue the merits of the statute for the first time in oral argument, that she has waived that argument. But even if she has not waived that argument, that statute clearly only applies to cases filed on or after July 1st of 2013, especially related to the section that she cites, which is 702.015. That section specifically does not apply unless the case was filed on or after July 1st, 2013. And finally, Your Honors, I know Ms. Zorie mentioned that that we're seeking to amend the complaint and that it's late. It's late in the case because judgment has already been entered. But the case law supports amending pleadings even after judgment has been entered, and we cite several cases in our briefs that support that proposition. And again, Ms. Zorie would not be prejudiced by this amendment. Prepayment is irrelevant, and she has notice of the prepayment rider's terms. And we simply request that judgment on the pleadings be reversed, and that to the extent necessary, NATIONSTAR be granted leave to amend its complaint to the extent necessary. Thank you.